Most of the time, there is a direct or indirect connection between a section and an amendment section. I said most of the time, it is not always. And one such example is section 113 and the two amendment sections, that is section 113A and 113B. Now, there is no connection between section 113 along with these two amendment sections. And here, more than section 113, the two amendment sections are very important, which are discussing about presumption as to suicide or dowry death. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were discussing chapter 7, which is all about burden of proof, covered between section 101 to 114A. And in that series, that means chapter 7, this is my 8th video where we are going to focus on section 113, 113A and 113B. 113 is just a formality, and I am going to focus on section 113A and B, which are very interesting. Not taking much of your time, let's get into business. Section 113. This particular section discusses about proof of cession of territory. Now, one very important aspect you need to remember is section 113 is an obsolete section. That means this section is no more applicable. This is being removed from the Indian Evidence Act. Why I have kept this section? Because from section number 1, we have discussed every single section from Evidence Act. So just to ensure the continuity, I have given section 113 here. Along with that, this particular section also refers part 3 of the Government of India Act 1935. So I have given all the chapters available under part 3 of the Government of India Act 1935. This is just for the purpose of notes, and remember, this is not important as far as academics are concerned or practice is concerned. This is an absolute section. So let's move to section 113A and B, which are very important, and I have some very interesting case laws for them. Let's get into them. Then comes the very important amendment section, that is section 113A. This section discusses about presumption as to abatement of suicide by a married woman. Now, the provision is quite lengthy. Let's quickly read through it before getting into the simple chart. The provision says, when the question is whether the commission of suicide by a woman had been abated by her husband or any relative of her husband, and it is shown that she had committed suicide within a period of 7 years from the date of her marriage, and that her husband or such relative of her husband had subjected her to cruelty, the court may presume, having regard to all the other circumstances of the case, that such suicide had been abated by her husband or by such relative of her husband. Here comes one very important explanation, which says, for the purpose of this section, cruelty shall have the same meaning as in section 498A of the Indian Penal Code 1860. Though the section is quite lengthy, this is in a very simple English and easily understandable. However, I have made it further easy with the help of my chart. My chart has just 4 boxes, and let us try understand them one by one. The first thing, the scenario. A woman has committed suicide. Now, such woman has committed suicide within 7 years of her marriage. Now, these are the two very important things. One, a married woman committed suicide, and that suicide is committed within 7 years of her marriage. Now, in that case, if the court has the question that whether such suicide is the result of abatement of suicide by her husband or her husband's relative, Now this is the question in front of the court, whether this is abetted by her husband or his relative or not. When that question is in front of the court, after considering all other circumstances, may presume. Here the very important aspect you need to remember is the court may presume. The court has the right to presume after considering all the other circumstances, and if there were instances of cruelty by her husband or his relatives, the court may presume that such suicide is an act of abetment, or such suicide is the result of abetment by her husband or his relatives. That's what we need to understand from this particular section. The last part of section 113a, which explains that for the purpose of this section, cruelty shall have the same meaning as in section 498a of Indian Penal Code 1860. Here I have given section 498a of IPC. You can take screenshot for the purpose of notes, and with that I am moving to case laws. Coming to the case laws, the first case law that I am discussing here is Jagdish Chandra versus State of Haryana, where it was held that drinking alcohol and coming late to home is not cruelty, but only if further beating etc. were done, that will be considered as cruelty. If drinking alcohol and coming home late, if that is considered as cruelty, then you can imagine the situation. So that can't be the situation. So that is what very clearly held in this particular case law. And another very interesting case law, that is Alka Grewal versus State of MP, where it was held that section 113a is applicable only to wife. If wife commits suicide after cruelty, then section 113a comes into picture. If husband commits suicide within 7 years of marriage because of cruelty by wife, in such circumstances section 113a cannot be applied. Here wife had some illicit relationship and husband felt mental cruelty, and as a result of that he committed suicide within the 7 years of their marriage, and family contested that section 113a shall be considered. But here in this case law it was held that section 113a applicable only to those cruelty which is experienced by the wife but not the husband. That's what we need to understand. Then I have given as many as 7 important case laws which are discussing about the importance of dying declaration, or when dying declaration of such wife can be considered, when cannot be considered. All of that are discussed in these 7 case laws. Here they have experienced cruelty, they tried for suicide, and before dying they have made a statement that their husband is the reason for their suicide attempt. Now here most of them were burnt more than 90% or so. In that case, whether the court shall consider their dying declaration or not, that is what discussed here in these case laws. And among these, Paniben versus State of Gujarat is one of the most important case law, where Supreme Court very clearly set up a guideline that how exactly dying declaration to be considered. I have discussed all those guidelines in my session on section 32 clause 1, that is on dying declaration. You can refer that video for understanding these case laws, and you can quickly read through these case laws where you can see lot of them have burnt more than 90% or so, and whether the dying declaration can be considered or not is discussed in these case laws. And with that I am moving to the next slide. Then comes section 113b. Now this is presumption as to dowry death, and the provision says when the question is whether a person has committed the dowry death of a woman and it is shown that soon before her death such woman had been subjected by such person to cruelty or harassment for or in connection with any demand for dowry, the court shall presume that such person had caused the dowry death And here explanation says, for the purposes of this section, dowry death shall have the same meaning as in section 304B of the Indian Penal Code 1860. After reading the provision under section 113B, you might be feeling that there is a difference between section 113A and B. Under section 113A, we have understood that husband as well as relatives are covered. But here there is no mention of relatives. Likewise, under section 113A, we have seen the number of years. There it has very clearly mentioned within 7 years of her marriage. But here there is no such mention. Now you might be thinking that way it is two different sections. But remember, section 113B need to be read with section 304B of Indian Penal Code. That is very clearly mentioned under the explanation of section 113B, which says dowry death shall have the same meaning as in section 304B of the Indian Penal Code. And under that particular section, it is very clearly covered that where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relatives shall be deemed to have caused her death. Now that's the beauty of section 304B, and from there we have to start reading section 113B. Here, if the question in front of the court whether a person has committed dowry death or not, if it is shown that soon before her death she was being subjected to cruelty or harassment for dowry or in connection with demanding dowry by her husband or his relatives, the court shall presume. Here the words are very clear. The court shall presume that he has caused dowry death. Now he or his relatives, because the section very clearly in the explanation asks us to read dowry death along with section 304B of IPC. So we have to read all of them together. He or his relatives, and within the 7 years of the marriage, and what kind of death, which may be caused by any burns or bodily injury or occurs otherwise than under normal circumstances. All of them are covered here, and that shall be presumed by the court that it is dowry death. That's about section 113B, and let us see one case law, that is State of UP versus Hari Mohan. I have given all the facts that the Supreme Court has given here before giving the judgment, because this is a very interesting list of facts listed by the Supreme Court. And if you want to face the judiciary exam, this can be one of the example that how exactly you are finally putting the evidences in a good place. Now the background of this particular case law is a daughter wrote a letter to her father saying that her life is in risk, and if ever she dies, the reason for the same will be her husband and in-laws. Receiving that letter, father comes to the daughter's place, and when he asks about his daughter, the husband and the family says that his daughter is already dead due to cholera. Now, as I have already told, he has received a letter from his daughter. On receiving the letter, he doubted that his daughter's life is in risk, and that is why he reached there. Now he goes to police, and police start the investigation, and then all of these facts are coming into picture. That there was a demand for dowry, and one of the husband's brother had a licensed gun, and he has shot on a particular day and that sound was heard by some people, and on investigation the daughter's body was also found in a gunny bag with the wounds by the gunshots, and there was sufficient distance from gunshot of more than 4 to 6 feet, which very clearly said that it is not suicide. With all these facts, the Supreme Court of India held that this was a dowry death. This is one of the classical case as far as section 113B of Indian Evidence Act and 304B of Indian Penal Code.
Papa, why taking rest is so important?
Nishan, we are living in a busy world. Everybody is busy in working. Work, work, work. And when we work so much, we get stressed. And if we don't take rest, then all the other work gets spoiled. And when we think of rest, it is not that go and sleep. Rest means changing from one work to another. So everybody should keep changing their work to ensure that they are reboosted and they have more energy to continue with quality of work.
With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.